Hello, my name is Eric Willison. I am an Ohio attorney. I do a lot of work in landlord-tenant law here in Ohio. Today we're going to be talking about evictions, specifically defending evictions, and some of the defenses that tenants can have. Now, in previous videos we talked about the three types of defenses. We've got what are called merit or factual defenses, like the tenant didn't pay the rent. Oh yes, I did. Tenant's got an unauthorized dog. Oh no, I don't. Those sorts of things. Then there's the legal defenses, whether you're legally entitled to an eviction. Is what the tenant is doing, is that a breach of the lease? When it says you can't do this, how clearly does it say that? Those are sort of legal defenses. Then there are the devilish ones, which are what I would call procedural defenses. And procedural is sort of like, how do I want to say it? Sort of like not a cheap argument to make, but it's just sort of, it's definitely not one that's based on fairness, but still effective. That's the problem. Now, there are two particularly devilish things that tenants can do to forestall an eviction. And the first of those is to go outside and remove all indications of the address from the premises. So if you live at 1820 Main Street and you've got those nice little, little brass plaque that says 1820 on it, or those little sort of black wrought iron letters out there, whatever. Well, if you look really closely, they're either glued on, or they're maybe nailed on a plaque or something, or they're screwed on with the screwdriver and screws. The tenants will just get out there and they'll just take them off. And then when the bailiff goes out there to serve the address, well, I got 1816 right here, and I got 1824 right here. That's probably 1820, but there's just nothing on there. And a lot of these bailiffs are just not going to serve the place unless the eviction is clearly stated as to, I should say, the address is clearly stated. They're just not going to serve it. So it'll come back as non-service, and you'll get to your eviction, and the court's not calling the case, and you go up to the bailiff, hey, what's going on with my case? Oh, that's a non-service one. The bailiff couldn't find the address. And you're like, what do you mean the bailiff can't find the address? Well, so what you might want to do before you go and file your eviction is maybe go out there and just make sure that that's not what's happened. Now, another devilish thing that can happen is where, as I spoke about in a previous video, most evictions occur in a municipal court. I would say probably about 99% of evictions are in a municipal court. Now, occasionally, an eviction may have to be done in the court of common pleas, but that's pretty rare. But it's not rare at all if you've got a tenant or a tenant's attorney who knows this trick. And what it is that the tenant will file a counterclaim to your eviction. Maybe they'll say this is a retaliatory eviction, or the landlord isn't fixing things around the place. That's not a defense, but it is a counterclaim for diminished rental value. They're basically saying, hey, I pay $1,000 a month in rent. The landlord's not fixing things, so my place isn't worth $1,000. In fact, I don't think it's worth a damn thing. And because of that, I'm over the $15,000 limit of the municipal court. Therefore, it has to be transferred to the court of common pleas. Now, that would seem fairly simple. The tenant makes a motion to transfer, and then you would think, well, it just goes right on over there. Not so fast, Batman. What happens is, unfortunately for the landlord, there's usually a difference in the filing fees between the municipal court and the Court of Common Pleas. So let's say in Franklin County, in 2021, to file an eviction, the filing fee is $123 for the initial fee. If you want to file it over in the Court of Common Pleas, you're at about $230, $236 or so when you add in the electronic filing fee, user fees, and all that kind of stuff. Well, they're not going to transfer it over and accept it until you pay the difference between the two. And you have to understand that does make a little bit of sense, because otherwise everybody would just file everything in municipal court for $123 and then just transfer it for free over to the Court of Common Pleas, and they've just saved themselves about $100. So the Court of Common Pleas way of getting around that is to charge an extra fee. But here's where the deviltry comes in. The tenant makes the motion to transfer, but then doesn't pay the transfer fee. And what happens? Nothing. The case just sits there until somebody pays that transfer fee. So if you are the landlord and you're wanting to get that tenant out and you want the case transferred over to Court of Common Pleas because the tenant's raised this issue and the tenant has filed his or her motion, you need to go down there and check to see whether that fee got paid. And if that fee didn't get paid, you need to go fork over that money. Now that's going to steam you because, well, why doesn't the tenant have to pay this? Well, the tenant should pay it, but the tenant's not going to, because that buys the tenant time. But if you go down there and check every day for a few days to make sure that that thing's not paid, if it's not paid, you go down there and pay it, then you're going to have that hearing over in the Court of Common Pleas a lot quicker than if you just let the process grind, because it'll grind for 3, 4, 5 months. And that is a problem when you have to pay the mortgage on that place, or you've got the tenant's unauthorized dog tearing the crap out of it, or you've got loud, noisy tenants who are running off the good tenants, or whatever. So those are two tricks that I've seen: the remove the address so that they can't get service of process, or file a big counterclaim and make a motion to transfer, but then don't pay the transfer fee, and then everybody just sits around and nothing ever happens. So those are two to look out for if you're a landlord. If you're a tenant, I can't recommend you use these things because it's not in keeping with judicial economy. It's not in keeping with ethics if you're a lawyer for a tenant to advise them to do these things. But, you know, I hear murder is illegal too. And yet I'm told it happens. Strange.